So first up for this press conference about the U.S. District Court decision on the Front Street Apartments case, we have Victor Gemignani, who's the founding director of Lawyers for Equal Justice, to start us off.
Thank you, Will. Good afternoon. Let me give you a little bit of context. Front Street Apartments was built in 2001. It was comprised of 142 units of very low-income housing. Let me stress what that is. 50% of the units had to be given to only people with 50% of income, 50% of the AMI rather, and the other 50% of the buildings had to be given to people that were up 60% of AMI. So everybody in the buildings are ultimately 60% of AMI or below, which is a very, very low income level. In order to be able to build the apartments, the developer was able to receive $15 million from the state in terms of tax credits, and $5 million from the county in terms of real estate tax reductions. In order to get those dollars, that support, they had to guarantee that the property would be affordable for 51 years. After only 15 years, the developer decided to try to opt out, and unfortunately was able to do that temporarily until the judge ruled recently, last night actually, that the decision that was made to allow them to opt out by HHFTC was in fact incorrect. We were able, when we got involved about 3.5 years ago, to develop an incredible litigation team. Lance Collins from Maui joined us, and an incredible firm from the international law firm Hogan Lovells joined us from Colorado offices. The bottom line is the judge ruled that once a promise was made and consideration given, the developers were going to be bound by that promise and going to have to keep the places affordable. And by the way, they were going to double or triple the rents. That's what they had already decided to do, in which case virtually all of our tenants would have been evicted, 350 people that are low income and disabled and elderly and working 1 or 2 jobs, 2 or 4 jobs to support their ability to live there would have been evicted. Tom, you want to talk a little bit more about the background of the case or the substance of what the judge ruled?
Yeah, I think we all know that there's a huge housing crisis in Hawaii, and the government, the state government, and the federal government have incentives in place to encourage people to build low-income housing. And Front Street Apartment is one of those apartments that was built with a lot of state and federal money. But the money comes with a condition, which is that it has to, the units have to stay affordable. And so this lawsuit was aimed at enforcing that condition and enforcing the promise on the developer. And I just want to highlight that it was a real shame, we think, that the state, the state of the Hawaii Housing and HHFTC, which is the agency that is supposed to protect the state's investment in low-income housing and low-income tenants, really defaulted on its obligations twice in this case. First of all, when the developer asked to be let out of the promise that it made to keep the units affordable until the year 2051, HHFTC said yes to that request. And Judge Otake in her decision clearly said that giving the developer permission to get out of its promise was wrong and not in accordance with federal law, not in accordance with state law. So that's point number one, is they should not have let, the state should not have let the developer out of its promise. Then the second time, when we, the lawyers and the tenants of Front Street, brought that breach to the attention of the state, of the HHFTC, by bringing this lawsuit, HHFTC should have come on board on the side of the tenants in the lawsuit to protect them from the doubling and tripling of rents and from taking this precious resource of affordable housing out of the housing stock on Maui. Instead, HHFTC lined up with the developer and fought us the whole way until the case was, until the judge made her ruling. And so we really appreciate the ruling that the court made, making clear that the property has to remain affordable until 2051. That's the major point. But I also just want to give credit to our three plaintiffs, Joseph Vu, Chai Geyer, and Mike Tuttle. Mike and Chai are on the line with me now and are available to talk if you want. But they're the people who really stepped up for all the tenants, the 141 tenants, for all the people the low-income people who might want to live in Front Street apartments in Lahaina anytime in the next 35 years, and will be able to do so because of the efforts and the courage of these tenants. I just want to express my appreciation to them.
Okay, next, thanks, Tom. Next, we have Lance Collins, attorney for the plaintiffs.
Thank you, and thank you everybody who could make it here this afternoon. I do want to echo what Victor and Tom have said. In addition to the federal and state benefits that the developer got to develop this project, the developer also received approval through the Affordable Housing Fast Track process, which allowed it to be exempt from a number of zoning and building requirements so that the project could be built. And also, because of the affordability requirement, it also got what essentially was a rebate on its real property tax. And I think it's very important to note that when the council approved this in 2001, the representations that were made, which were reflected in the declaration that was signed, was that this was going to be affordable for 51 years. And so it's always very concerning when one representation is made to the county to get these special tax breaks and zoning concessions to build affordable housing, to then turn around 15 years later with 36 years left on the timeline for affordability and try to move these types of units into market rate. There's a tremendous need for affordable housing for workers and others that are on fixed incomes in Maui. And it's really almost unconscionable that somebody would want to take these units out and turn them into market rate. And I think I speak for everybody that it's a great thing that the legislature was able to step up and provide funding to purchase the underlying fee and to also eventually purchase the ground lease that the developer holds, and also to provide more affordable housing solutions for West Maui during this process. And it was very important to have this lawsuit because without the stipulated agreement that rents would not be increased on tenants during the duration of this lawsuit, everybody who is currently a tenant in an affordable unit would possibly be subject to market rents at this point when the qualified contract, the extended period had ended. And so I think it's very important to note, not just that this decision is so important in terms of protecting these 142 units, but also that the process of litigation was the only thing that allowed these units to remain affordable while the political process is able to work itself out. And so we're hopeful at this point that the state aligns with the tenants, aligns with taxpayers, and gets this project from the developer at the correct value, and hopefully can keep it affordable in perpetuity, even beyond the 51-year requirement. So, and I also want to express my tremendous gratitude and deep respect for the plaintiffs, the tenants in this case, who really had to not only endure the uncertainty of whether or not they would be able to remain in these units, but also to have to bear the burden of all of their fellow tenants' own uncertainty and ambivalence about this very confusing and uncertain process that has now resolved in the favor of the tenants.
Okay, thanks, Lance. And now, Tom, you've got the two of the plaintiffs on the phone. Do you want to have them say something?
Mike or Chai, I don't know if you want to say anything, if you want to just see if there's questions, but if you want to speak up, the floor is yours. Mike, let me turn to you first.
Okay, well, thank you very much. Gosh, this is such a huge relief. I can't tell you, over the last three and a half years, everyone living there, hundreds of people have been living in fear and uncertainty, thinking that they were going to lose their home. And there's literally nowhere else to go for us. And so when Victor, I spoke with Victor about being a part of this, you know, honestly, I didn't have anything to lose. And because, you know, we stand to lose our homes. And so I didn't feel like I was doing anything heroic or brave or anything. It was a desperate attempt to try to save our homes and all of these people that were living in such uncertainty and fear. It was really, really incredible. And I can't tell you how grateful I am for Victor and Tom and Lance and everyone else on the legal team who took it upon themselves to save our homes. This is an incredible thing that I am just so grateful for. You know, raising kids is hard enough, and then going years of wondering whether we're going to be out on the street made it so incredibly difficult. And the feeling I have now, I can't tell you. I'm trying not to cry because this is such an incredible feeling to know that, wow, you mean I'm not going to lose, I have a place to live and I don't have to worry about, you know, being homeless. And I can't, for me, it's, you know, and I can only imagine how many of the other tenants feel because, you know, not everyone is even as fortunate as I am. In the respect of, you know, I'm not retired yet. I still can work, but many can't. Many are disabled. Many are retired, and to talk to them and see the fear in their eyes and the level of just desperation when we were discussing what are we going to do, what can we do, you know. And so I feel like, you know, this is just such a wonderful victory, not for me, but for all of these people that would have nowhere else to go. And I'm just so thankful and grateful. So yeah, I don't know what else to say.
Mike, I'm sorry, Chai, do you have anything to add to that, or?
I very much agree with what Mike just said. It's been a very stressful, difficult time over a period of years, and I am so relieved. I too feel like I could cry. I'm just so thankful for the help that our attorneys gave us pro bono, and the support and the diligence of following through with what they said they were going to do. I'm just so grateful and thankful. I'm 77 years old. I'm retired on a fixed income, and like Mike is saying, I have nowhere else to go, and a home is very important to me as it represents safety and security, and to be able to know that I have a place to live, and that I've been able to help my neighbors along the way. It's just so gratifying. So I am very grateful and very thankful.
Okay, thanks, Chai.
Yeah.
Okay,
Will,
yeah, do we have any questions?
we lose our?
Yeah. Oh, hi. So I can ask questions now?
Yes, go ahead.
Okay, sorry. Well, first of all, congratulations to you guys and to the tenants. I've talked to some of them over the years, and I'm really happy to know they're gonna have a place to live. But yeah, I just wanted to ask you guys if you could break down in layman's terms the main points of the judge's ruling, in addition to I know you talked about affordable through 2051, but if you could also just kind of go over some of the other aspects of it.
Well, I think it's Victor, do you mind? Can I handle this one? I mean,
No, it's really fairly simple.
Yeah, go ahead.
The builders accepted consideration dollars from the county and the state, both in terms of regulatory process of being waived, as Lance pointed out, as well as direct payments that they received So the judge ultimately said, when you make a decision and you sign your name to an obligation in the declaration that runs with the land, you have to fulfill that obligation that you made. So it doesn't go much more complicated than that. There were other causes of action that the judge didn't address because the issue was resolved on the first issues that she addressed. But the other issues in terms of the state's failure to engage in a process and adopt a procedure that would allow some order to the opting out process that they attempted to do. The fact of the matter is, no one knew that this was happening during the year period of time. And in fact, the first the county found out and the tenants found out that it was something that was going to be problematic in terms of their ability to retain the property was in June, only 2 months before the final time period of a year expired. No one knew that this was going on because of the failure of HHFDC. To develop a process appropriately and to implement a process appropriately. So I think the issues that the judge resolved were fairly clear. We had a couple of other precedents in other states, in Oregon and Alaska, which benefited us. But I just basically, I think, to be frank with you, this is one of the situations that lawyers just love because the facts were just incredible in our favor. People were going to suffer intensely, as Chai and Mike talked about, in terms of their lives and how they would have been affected dramatically with the eviction that was inevitable, given the doubling and tripling of rents. So the fact that we had great facts was wonderful, but the fact that we had great law, so the facts and the law combined to make a wonderful decision that ultimately will protect this property, I think, in perpetuity, as Lance said, to make sure that residents, not only the current tenants, but the residents that are of Maui that are eligible for this apartment building, very low income people that are really desperate for housing, now have some place to go for a very long period of time. Tom, did you have, Lance, did you have anything else to add in terms of that?
I would just say, you know, it was a 40-page decision, but basically the judge found that a contract is a contract. They agreed in return for millions of dollars of benefits to keep the property affordable until 2051. And they had all sorts of creative arguments about why they shouldn't have to live up to that commitment. And the judge had to go through each of those arguments one by one, somewhat complicated legal argument, but the judge, I think, had no problem in rejecting them one by one, but explaining for each why the developer and the state were wrong to argue that the developer could get out of its commitment. So it was a simple, relatively simple case, but there were some complicated legal arguments. The basic principle is they have to live, they signed a deal, they got millions of dollars in benefits for the deal, the developer did, and they had to live up to it.
Lance, other perspectives?
We lose Lance?
I was muted. No, I would just, I guess, to try to finish answering Colleen's question. You know, we raised a whole host of claims, trying to anticipate every possible defense that the developer might raise. And basically the gravamen or the crux of the case was the declaration does not allow the state to release the developer early. That was the crux of the case. And the court basically said that that's correct. The plain language of the declaration says there's no special process that allows the developer to get out early. We did raise a couple of other things, but basically the judge said she wasn't going to rule on those because the declaration is valid and the release was invalid. So all of the sort of alternate claims we raised were mooted because we got what we wanted. So I don't know if that fully answers your question or not, but.
No, that helps. Thank you. Thank you guys. And so the other thing is, so what is next for the tenants? Is that pretty much, this is the end of it now where the rents are going to be affordable for a time and there's no other action they're planning to take?
Well, they have the right to appeal. The defendants I'm talking about now. So we'll have to wait to decide and see whether they ultimately decide to appeal. But as of right now, the tenants are protected. And I, to be frank with you, think that even after an appeal, we will win that appeal also. Without too much difficulty, I hope. The tenants will be protected for as long as they want to live there.
Colleen, one thing that is probably unsettled, whether or not the developer appeals, is the fact that the developer has moved a couple of the units into market rent levels. And basically now, after the judge's ruling, that's illegal. So the state has an obligation now to enforce the requirements that they're affordable. So that's going to have to be worked out probably between the developer and the state. And of course, if the state doesn't do that, then it falls onto the U.S. Treasury to enforce what essentially is a tax law violation.
Interesting. Okay. Do you know how many of those units there are that were?
There were about 35 that were put into market rates. So those 35 tenants, our homes and our units, are going to have to be prepared to evacuate at some point to allow low-income eligible tenants to occupy those premises. And by the way, that's 35 out of about 142 units. So they moved very aggressively to try to privatize and charge market rates for all of the units.
Wow. So 35 units, the low income tenants were evicted and new tenants were moved in who could pay the market rate?
Well, they weren't evicted. The apartments became available. As Chai and Mike were saying, the tension and stress was unbelievable in the project. Because the uncertainty of where they were going to go and the fact that there was very little alternative space available anywhere in Maui for them. So bottom line is the stress factor was intense. I think that ultimately will allow them now to reduce their stress and live there as long as they want.
Got it. Okay, so the 35 weren't like evicted. Some people left.
No, they left voluntarily because, as I said, a lot of people were stressed and left anyway because they were desperate to find a place. So if anything came up anywhere, even doubling up with relatives, they went ahead and did it because their future was so uncertain. So those 35 units were basically made available by people vacating voluntarily. There were some evictions that were done, I know, but I'm not sure about the particulars of those evictions. But the majority of people left on their own volition. Remember, the deadline for the place going marketplace was last August. Mm-hmm. So as that deadline got closer and closer, people decided to seek any alternative means they might have, including moving away from Maui if necessary to find something, because the clock was really ticking and counting down very closely to the time when they may be evicted and homeless.
So I kind of have a two-part follow-up to that. One, do you guys know of some families who had to move out and are hoping to move back in now that it's going to be put back to affordable rates? And the second question being, what will these other families do who moved into these apartments? Where are they going to go?
Well, the people that are not eligible to live there at some point will have to vacate, and they are paying marketplace right now. Marketplace means there's other apartments in the available area that will rent for the same amount of money. So they're not under a lot of stress to be able to find an accommodatable marketplace apartment. So they will at some point have to leave. That decision hasn't been made in terms of how soon. That'll be up to a lot of discussions between interested parties to try to figure out what's equitable.
Yeah, and Colleen, to answer the other part of your question, we don't directly know exactly how the developer will, as these units become available again for affordability, but we do know is that during this process, because we asked multiple times, that there is actually a very long waiting list for individuals who want an affordable unit. And so so with respect to that, whether or not people who left voluntarily because they were, feeling under stress that they might get kicked out anyways, whether they'd be able to jump to the head of that line or not, I think is probably something that the state is going to have to direct the developer. I mean, the state's really going to have to take a more active role now in resolving all of these secondary issues, because it's the state that allowed this to go on for so long.
Other questions?
I think the last thing I wanted to ask was, so I know the state bought the land and then they also got the ground lease?
No, the ground lease is still in effect with Front Street Apartments. They have the ground lease.
Okay. The state
bought the land. They bought the fee. They bought the land. And one of the options the state was considering, I believe, is to forego the rent. The rent that is being charged, was being charged by the previous owner, was $37,000 a month at Front Street Apartments. One of the things the state, I think, had been considering is to waive that, which means you'd indirectly subsidize the owners again another $500,000 for the entire year, 37,000 times 12. And in the process, potentially preserve some of the apartments as affordable longer term, again, with the state subsidy. So at this point, we're saving the state a lot of money because they now can exercise eminent domain. And I want to point out one really important thing. The value of the property will now be decided based on the fact that it's affordable. In other words, there are restrictions to any owner that purchases the property that it must be kept affordable. That's going to reduce the price of the property from the $15 million that was originally appraised back in 2015 when this was starting as an unregulated apartment dwelling. This now will have to be evaluated as a regulated property value. So if the state decides to move forward with eminent domain, which I hope they will, and preserve this for the rest of our lives in Maui, that they'll have to pay hopefully a lot less money.
Just to add that Senator Baker has been a real leader in this area or in the effort to get by the property, to have the state buy the property. And I think this will make her job a lot easier by reducing the asking price.
Got it. Okay, thank you. That does kind of answer my last question, which was going to be about if you ultimately wanted to see the state acquire the entire apartment project. And that's what it sounds like you guys want, correct?
Well, they already acquired the land. Now we're hoping that they'll acquire the lease, which will oversee all of the relationships all of the tenants have in the project. So there's one more component of a absolute protection long-term past the remaining 36 years, if that's what's left in the original obligation. And that's for the state to, through eminent domain, purchase the property. But when they pay the value of that property in fair market, which is what eminent domain requires, the fair market will be a lot less than it was originally because it's, again, as I said, restricted.
And just to be clear, that this lawsuit, by winning the lawsuit, the affordability provisions are in effect to 2051. What we're hoping through the state's purchase to accomplish is to get those provisions in place past 2051.
Yeah, and also just to add to that, that the legislature, and I can't remember the act number off the top of my head, but the legislature actually did not order HHFDC to buy the ground lease, but basically told them to authorize them to do so, to negotiate by the end of last year. And then if that fell through, then to go through eminent domain. And I think because of COVID and whatever the other reasons are, that the eminent domain process hasn't started yet. But I know the county has said that they would contribute to an eminent domain process to obtain the project. So definitely now that it's without any question, that will be affordable for another 31 years. The market value of it is not going to be basically an oceanfront market rate apartment complex, but an affordable housing complex. So that will definitely affect the price that will be for the unit, for the project.
Great, thank you guys. And should I describe you all as attorneys for the plaintiffs, or how should I describe?
Sounds good. Sounds good.
All attorneys for the plaintiffs. Okay.
Fair enough. Yeah.
Great. Okay. Thank you guys so much. I really appreciate it.
Sure. Thank you.
Thank you.
Thanks, Colleen. There's a Lauren Hallinan in the meeting. Did you have any questions?
Oh, hold on. Hey, no, I just thought that was a great presentation, and it really clarified this incredible job you did. I agree with Victor, like what a great case, and I really congratulate everybody on it. You got a wonderful opinion as well. So I enjoyed hearing it because it clarified, just reading the opinion. I mean, it was very complicated to read it, but I worked in housing issues a long time and on homelessness, and so it's fantastic to see you guys get such an incredible result. So congratulations to all of you.